The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. There'll be 4 cases submitted this morning. The first 2 cases will be submitted with oral argument. The final 2 will be submitted without oral argument. Those cases are Service Employees International Union, Local 199 versus State of Iowa, Iowa Board of Regents. Second case is UE Local 893 IUP versus State of Iowa. The third case is Rivette Sauzer versus State of Iowa. And the final case is Myron Dennis Boehm and others versus City of Cedar Rapids and Gatsco, USA, Inc. Again, those final 2 cases are submitted without argument, and we'll now hear the arguments in Service Employees International. Mr. Gribble.
Mr. Chief Justice Cady, Justices Mansfield, Appel, Wiggins, Waterman, and Christensen, may it please the Court. This is an appeal from a decision by the District Court in and for Polk County. The case arose when SEIU, the union, filed a petition under Iowa Code Section 20.17 to enforce the terms of a collective bargaining agreement between the union and the regents. Now, the regents and SEIU commenced negotiations for a successor contract in late November of 2016. They exchanged initial proposals on November 29th and met again in December on the 8th and 14th. They had meetings scheduled for January 5th and January 12th of 2017. The regents canceled those meetings and instead on January 10th presented the union with a contract proposal, a little different than ordinary bargaining proposal because it was a complete collective agreement. It's in the record as Appendix 18. And that contract from the regents, which was drafted by the regents, consisted of 25 articles. It had all the provisions in predecessor contracts, plus some things that the union wanted, more that the regents wanted to have. It was complete, it was for a 2-year term, it had signature lines, and it was a final offer. It was presented as take it or leave it. The union, after considering the matter for a couple of weeks and inquiring if better terms were available, finding they were not, accepted the offer on January 25th and ratified on February 7th. That completed all the requirements for a contract under Iowa Code Section 2017-4. And yet the district court concluded there was no contract on 2 grounds. Basically a PERB rule, 6.4, in Iowa Code Chapter 21. First, the rule. The rule 6.4 states that even though this contract was drafted by the regents, presented by the regents, offered by the regents, accepted by the union, ratified by the union, it still had to go back to the regents for another approval. And the question presented, the initial question, is whether PERB can by rule add an additional requirement for contract formation not found in the statute.
Even without the PERB's rule, don't we have this body of law that says a municipality or a government body or quasi-government body such as the regents can't be bound unless they actually approve the contract?
We do, Justice Wiggins, and that is really the second argument in Chapter 21. However, Justice Wiggins, that does not apply to collective bargaining agreements. With respect to public sector collective bargaining agreements, there's going to be a contract whether the employer approves of the agreement, ratifies the agreement, or signs one. And that's because of the law itself. If, for example, the union did not accept this contract offer and instead said, no, we'll just go to arbitration on all those provisions, then the arbitrator under 2211.
How does the rule of arbitration overrule the body of law that says a government body can't be bound unless they actually approve a contract?
It does, Your Honor, because it is a more specific statute. And there is going to be, there has been, and many times there are and have been contracts in Iowa that the employer never approves. There certainly was one in the state of Iowa in 1992 where the parties agreed to everything but wages. The arbitrator determined the wage issue, and that issue ended up in this particular court. But because it's a more specific statute, and Iowa Code Section 202211 says that the decision of the arbitrator, along with the other items agreed to by the parties during the course of bargaining, constitute the parties' collective agreement. So if we had agreed on nothing, then the arbitrator would have resolved the entire contract, and there would be a contract in effect.
Let me sort of turn to that other angle of the case, and I'd sort of like to invoke that complex legal principle, you know, what's good for the goose is good for the gander. Your client didn't ratify the contract until February 7th, correct?
That is correct.
So until then, they were not bound, right?
Until such time as we ratified under the law, 2017-4, ratification was a necessary element for contract formation.
And the Board of Regents argues, well, prior to that time, in effect, on January 31, Mr. Galloway in the phone call, he didn't say the offer is withdrawn, but he said there is no deal at this point. Why doesn't that amount to taking the contract off the table prior to the ratification, which would mean there is no contract?
Justice Mansfield, looking at the law and citing the cases, Pepsi-Cola and others that we have cited, it's quite clear that in order to do that, they would have had to use those words, that we're withdrawing our offer that we made to you. They never did that. They never withdrew the offer. They claimed there was an agreement, but they never withdrew their proposal.
Doesn't the Eighth Circuit use some language when a reasonable person would conclude that the deal was not on the table at that point, that's sufficient to withdraw it? You don't have to use the magic words, I withdraw, right? Isn't that what Pepsi-Cola says?
They do, Your Honor, but they went much further than that. They said that even if the employee organization wanted to strike, even if they presented other counter proposals, there still would be a contract unless the employer specifically withdrew their proposal. They had to use that term. We're withdrawing our offer. Otherwise, there's a contract.
What about the commentary that was made, I think, at the December 8th and 14th meetings, and you have the affidavits of Cook and Galloway, and I'm paraphrasing it a little bit, but it was something to the effect that any terms agreed to at the bargaining table would have to be approved by the regents, and that he would have to, he being Galloway, I think, would have to sell it. The argument is, well, back in December, it was clear that anything that we agreed to at the bargaining table would have to be approved by the regents. Am I mischaracterizing the record? And B, what do you make of it?
Justice Appellee, you're not at all. That is in the affidavit. That's what he said. We don't think, based on the facts of this case, so that's particularly relevant, because a month later, what the regents did is they drew up their own contract. They submitted it to the union. The union accepted it and ratified it. So there was nothing to sell back to the regents in this particular case. In other words, this contract was prepared by the regents, offered to the union accepts, ratifies, contract under 2017-4. So, except that he made that statement, I just don't believe it's relevant here. I'd like to go back to, first of all, the rule itself. On 6.4, the validity of that particular rule. We think that that rule is beyond the power of PERB to enact. The PERB has the power to promulgate rules to implement the provisions of the statute, but not to add to them. And the clearest way I think I can point that out is if we look at 2017-4, we've got a contract. We have offer, acceptance, and ratification. If we say that no, PERB can also promulgate this rule, and we need this rule, we don't have an agreement. To me, that's the clearest way to express that this is beyond the power of PERB to enact.
How long has the rule been on the books, Counsel?
The rule's been on the books almost since the beginning of the law itself, very early on.
As recently as last spring in the Mormon case and earlier cases, we've noted that we can uphold a rule on the basis of legislative acquiescence when the legislature doesn't step in to overrule an administrative rule. Does that doctrine cut against your position here today?
I don't believe so, Your Honor. At least in Iowa Department of Revenue and Nishnababwa, you did confront that particular issue and did make statements that it didn't matter how long the rule had been in effect or how often it had been applied. This is the first time, you're quite right, that it's been raised. It has been accepted over the years. Neither side has challenged it. That is correct, but I don't believe it undercuts our position because of the court's pronouncements on that subject.
Does the rule really add a requirement, or is it a requirement, to follow up on Justice Wiggins' question, a requirement found in other statutes and the body of law governing public entities that they have the right to ratify?
Your Honor, you're quite correct, and that was the second argument, Chapter 21, that every contract in Iowa must be approved by the governing body in public session. Chapter 20 is just an exception to that because, as the court said in Pepsi Cola, and as you've alluded to in other cases, the contract here presupposes the beginning of negotiations. Once a certified bargaining agent initiates the process, there's going to be a contract by operation of law in Iowa, whether there's acceptance or ratification or not. Because if the parties agree on nothing, the arbitrator will decide on everything, and by law, 2022-11, that is the parties' agreement. If the more common cases where the parties reduce the number of items and get to mediation, they then have to identify for each other what items are still in dispute, and they have to submit that to PERB. Let's say it's wages, hours, and insurance. Mediation resolves hours and insurance, but they still have wages. They don't have a voluntary agreement, so there is no vote by anyone.
What if the union representative went to the regents and said, this is our final offer, take it or leave it?
If we
And
did
then-
that and
the
said
reg-
that,
And let me finish, and the regents then ratify it. Is that a binding contract?
if the regents then ratified, the union would still have to ratify under the law. The obligation under 2017-4 is for the union to ratify.
The ratification, according, is your position, is only a one-way street.
Well, not according to my position, Your Honor, according
Position
to
of the law,
the
your
statute.
position of the law, it's
Right.
only a one-way street.
Right. And we're saying the legislature could have added an additional requirement, but they did not.
Let me ask you a question. On January 31, if Mr. Galloway had sent a letter instead of having this meeting where there was, or phone call, whatever, phone call, I guess it was, he had sent a letter and said, the Board of Regents hereby withdraws its initial bargaining proposal, which under Pepsi Cola would have eliminated any ambiguity, right?
That is correct, Judge
If they had
Mansfield.
done that, would that have been, it's not unfair labor practice, prohibited practice? Would that have been a prohibited practice, failure to bargain in good faith?
No, if they had sent a letter saying our offer is withdrawn, I suppose other issues could arise, but on its face, I think, trying to answer just to your question, there's some case law or some, at least opinions, that would have been sufficient. But that's what it would have had to have been, and that is not what it was. It's that we don't think we have an agreement, we need to continue to bargain.
So there's no legal requirement in this area of law that bargaining in good faith requires you not to withdraw your initial contract proposal?
Not standing by itself, but what PERB has said on that is always a totality of circumstances. You get it, everything that surrounds it. How many times have the parties met, if they made a movement in their positions? There are a lot of other factors.
Okay,
But standing alone, I can't say that it would constitute a prohibited practice.
thank you.
With respect then to the contract, we believe that we've got an agreement based on offer, acceptance, and ratification of the parties here. We do not believe the rule is controlling because only the legislature could add an additional requirement. We don't believe that Chapter 21 is determinative here because there's a specific exception in Iowa Code Chapter 20 that provides for a contract by operation of law if the parties can't agree. They can't agree on everything, the arbitrator decides it all. If they agree on some things, then the parties resolve those at the bargaining table. And you have to exchange then your final offer on any unresolved item within 4 days of your request for arbitration. In that case, the arbitrator rules on wages, for example, on nothing else, and the parties have an agreement. There's never a vote by the public employer in that particular situation, or the employee organization. The contract results from the application of the law itself. Thank you.
Mr. Gribble, thank you as well. Mr. Tice.
Thank you, Your Honor. Good morning. May it please the court, counsel. Andrew Tice of the Allers-Cooney Law Firm here on behalf of the State of Iowa Board of Regents. SEIU characterizes this case as about validation of the agency rule. But the agency is not here to defend and explain the basis for its rules, so we really don't think that's what this case should be about. Instead, this case is about whether this court would want to alter a long-standing and fundamental principle that requires that governing public bodies ratify tentative agreements reached by their representatives before you can have
The
enforceable
legislature
contract.
can modify that rule, can't they?
The PERB rule?
No, the legislature.
Yes, the legislature would be free to enact a statute that would overrule an agency rule.
When I read chapter 2017, subsection 4, it basically says the only person who has to ratify it is the union. It doesn't say that the regents have to ratify it.
The point, if you're looking at the last sentence, Your Honor, of 2017 subsection 4, the collective bargaining agreement shall become effective only if ratified by a majority of those voting by a secret ballot. That, of course, would indicate that, yes, indeed, to have an enforceable collective bargaining agreement, the union is going to have to ratify that. That's not a disputed point. But that's not an exclusive requirement. That's a
But the
threshold
legislature
showing.
put in there that it has to be ratified by both. If they wanted it to apply, it seems to me by not putting the governing body in there, they may be, and I don't know what the answer is, but they may be indicating that it doesn't have to be ratified by the governing body once they make a binding offer.
So a couple of points that would go to that issue is the statute does start with saying that the terms of a proposed collective bargaining agreement shall be made available to the public. The use of the word proposed indicates that this agreement, before it's been reached, before it's enforceable, has to be disclosed to the public, which our position is that that requires an open session, which is precisely what the regents would do when considering a tentative agreement, is it would take it to an open session with notice to the public beforehand, whereby the public can be aware before there's anything that's final. So the use of the word proposed, which is not necessary to the statute, would suggest to us it has to go through the formal process. I would also add to that one of the cases I intend to discuss, if I may, is the Board of Regents versus United Packing case. That's a case that came down before this statute was entered. And our position on that case is that it does, therein, this court indicated that we have to go through the formal ratification process from the government public body.
But of course, if you have an arbitration award, there's no ratification.
Of course, it would be very similar to parties going to court, that of course if you're in court, the court has jurisdiction, can
Well,
enter.
it's fair to say that under Chapter 20, there are some resolution that doesn't require the governing body to approve. And so the question is, I mean, Mr. Gribble's making the argument, well, Chapter 20 kind of stands on its own, and it does provide, at least under certain circumstances, undisputed really, that you don't need the governing body approval, and that this particular provision demonstrates that you don't need approval of when basically a final offer has been agreed to.
Well, I think going to the first part of what I heard, Your Honor, being that there is an exception, yes, when there's an award by an arbitrator. As I said, very similar to any other party that might find themselves in front of a court. Even if they disagree, you can still be found responsible to follow the court's ruling, and the same thing applies to the arbitration.
You make this point about the open meeting law, but the rule on its face, if the rule is valid, applies whether you have a decision-making body that has multiple members or just one, right?
The rule makes no distinguish.
Right, so in that case, you wouldn't care about, with a single decision-making authority, you don't need to worry about open meeting or any of that, right?
It could be. The circumstances of our case, of course, involve a board, so I've not done full research for an individual governing public entity, but instead we're looking at the board context here.
Let me ask a question. This was a proposed contract, did the Regents come to these terms under this record, does it show at a meeting? Or was it done like in the back room?
There was no meeting. This record shows no meeting whatsoever. In fact, the affidavit submitted by Mr. Galloway shows that while he was serving as the representative and bargaining, at no point did he have the opportunity to meet with the Regents themselves. Instead, he was...
Well, that's kind of extraordinary, because when he makes his final offer, he talks about the authority that he's been given by the regents.
Yes.
We have I mean, we're not talking about bullets flying around, which we're all kind of familiar with. I mean, we're talking about really an integrated proposal, at least, is being exchanged. And then the representation is made that it's a final offer, and at least the suggestion is it's been authorized by the regents. I mean, so what do you make of all that? I mean, you're familiar with the emails I'm talking about.
I am, of course. Yeah, and I think that it's probably not uncommon for bargaining in the sense that there's an awful lot of back and forth and what you're...
We should say, well, that's just puff?
No, I think what we see is part of the concern if we were to loosen the standard at issue here and say that we could have binding public contracts based upon emails rather than a meeting whereby we set forth all the members and the votes and the actions taken. But here we've got shorthand commentary and emails that
Looks
indicate...
like from if I'm a listener and I get that, it looks like that the negotiator has met with the board, has gotten some authority, and is negotiating and is giving a final offer consistent with the authority I have. At least that's how I read the email. And
The emails that you're referencing would also reference the hospital. Says that I'll be meeting with the hospital and the regents, which of course we can all recognize with the hospital. What that's a reference to is staff at the hospital. And with regard to the regents, very same meaning could be applied to it in that it's staff at the regents, but not the regents themselves. It's people that would coordinate these before they go before the board.
it seems to have
in
a
meeting.
King's X quality to me. I mean, you know,
Excuse
it has a King's X quality. Here's my final offer. It's you know, if I were negotiating a settlement in federal court and somebody came up to me and said final offer and so forth, and then turned out, well, I gotta have it ratified, I don't think I'd be very pleased.
And I would understand that. I think in this context, we have to recognize that it's collective bargaining, which is operating under a different set of
Should
rules.
have known he didn't really mean that he had authority from the regents.
No, I mean that authority has different meanings, whether it be a final authority to approve or whether it just means the monetary authority.
But I see that argument, which is developed in the briefing, but I don't see that in Mr. Galloway's affidavit. Was that his intent, to say that he only was talking about a different kind of authority?
Well, we can only go, obviously, by the evidence that's in the record, but I think we do need to combine that with the fact that Mr. Galloway's affidavit does say that during these bargaining sessions, he made it perfectly clear to the union that any agreement that would be reached by the bargainers would need to be approved by the board
But
itself.
that was in December, and ordinarily, you don't think you need to ratify a final offer consistent with my authority. Now, if you're quibbling around the table and there's moving pieces and so forth and so on, and then you say, well, this is outside the final offer I've made, I gotta take it back, we'd all understand it. But the statements that were made in December, I mean, arguably, don't apply when a final offer with authority has been made in January.
Well, there's no evidence in the record that would suggest that Mr. Galloway ever went back to SEIU and said, hey, what I told you back in December no longer applies. This is a different
But he made a
circumstance.
final offer with authority.
Yeah, and right, they were making offers all through the bargaining process, and this statement was made, I think, several different instances during the bargaining.
I'm more interested in the argument that, in effect, the offer was taken off the table in the January 31 phone call. And what's your reading of the Pepsi-Cola case? Is there enough in the record to conclude, to meet that standard of a reasonable person would conclude that there was not an offer pending as of January 31?
We believe so, Your Honor. The Pepsi-Cola case, if this court were to apply that precedent to Iowa law, does say that there would be an express withdrawal, or, as you were alluding to earlier, circumstances that would lead the parties to reasonably believe that the offer had been withdrawn. And that's the clause that I would highlight for the court here, that those circumstances would certainly appear, as in that phone call, the Regents' representatives made it abundantly clear that the Regents did not believe a tentative agreement had been reached and the parties needed to return to the bargaining table.
we're talking here about different scenarios and different people's intention and fact issues. This was done on a motion for summary judgment. I mean, are there enough fact issues to have this thing go to trial for some court to determine exactly what the state of the facts were?
And that's not our position, because what we believe is a lot of this questioning really goes to our point to say that if we're going to loosen these standards and get into what each individual might have been thinking and what might have been said at each bargaining session, we lose track of the obligation to the public, which is the public needs to know what's transpiring. And the present rule, as set forth by this court, says we're going to find that out by having an open
But your guy's
session.
part of the cause, because he's telling these people that this is a final offer, take it or leave it. There's a question whether it withdrawn or not, you know. As Justice Mansfield said, a reasonable person, that's usually a jury question or a fact question, what's reasonable and what's not. I mean, it seems to me that you can't set it up this way and then hide behind it. And maybe there are some fact questions there that some third party, which would be a judge or a jury, needs to resolve.
I think if you got far enough into the question of the withdrawal issue and whether it would be reasonable, that would be the type of fact question if we didn't have such a clear record from Mr. Galloway as to the basis of this communication.
But he could have made it much, much clearer by just, when he knew that SEIU was sending it to the union, to their locals for ratification, just sending a letter saying, hey, that's not on the table right now, right? He could
I
have
think
made it
in
very
essence, that's
clear.
what he did in the phone call, is he said, this isn't on the table. There is no tentative agreement. We need to return to the bargaining table. That admonishment just got disregarded. But if I could say then, this all starts with the proposition that the parties here recognize. We've had the law in place for more than 40 years. We all know that this board, the Board of Regents themselves, are going to have to give approval. Even if counsel advocates to this court that the rule in place wasn't valid or disregards this court's prior precedent from the United Packing case, that was the understanding for more than 40 years. So even during all of this back and forth, all of these conversations, these seasoned bargainers would have well recognized the law is going to require that eventually, once we get a tentative agreement, it's going to go to both sides for approval and ratification.
Had a chance to look at the law of other states at all? I mean, obviously, sometimes the statutes are framed differently and would have no particular application. Indeed, there's a number of states I know that explicitly require ratification of the governing body within the collective bargaining statute. But nonetheless, aren't there some states that actually do allow enforcement of a collective bargaining agreement without the approval of the governing body? And if so, do we make anything of it, or is this a fool's effort that we shouldn't bother with?
Well, in answer to your question, Your Honor, whether we should make anything of it, no, I haven't looked. So I guess that would probably tell you where I'm coming from. I've only looked at Iowa law as I'm trying to figure this question out. And I've looked most notably at the United Packing case, which was a consideration of a collective bargaining dispute, where this court said that the agreed terms could be adopted by the regents in a proper legislative manner. Now, we interpret this court's language for a proper legislative manner to mean in an open session where a vote is taken and votes are cast and received. It also says that such action does not involve an improper delegation of legislative powers to private persons, as there is no compulsion to sign an agreement, and the final decision remains in the Board of Regents. That's the language that came about in 1970 before we even had Chapter 20, which came about in 1974. And so it's our position that that case preceding Chapter 20 is the basis for Chapter 20 in the sense that there was no need for the legislature to expressly lay out and say, we're going to need to have this public body ratify this. That law was already in place.
That's kind of surprising. It almost, I mean, isn't it kind of odd they didn't put it in Chapter 20? I mean, if that's in our case law, and now we have this new, apparently comprehensive statute, maybe it's not comprehensive, but it was apparently comprehensive, and there's that case law out there, and yet they don't include it.
See, and our position is because that law was already clear and made, it didn't need to be said. But in fact, we'd look at it the opposite way. We have the statutory rule of construction that says that a statute will not be presumed to overturn long-established legal principles unless the intention is clearly expressed or the implication to that effect is inescapable. So we could flip that on its head and say, well, the legislature, if it intended to reverse this court's prior decision, could have put in there, this is intended to reverse and overrule that prior decision, but the legislature didn't put that in either. Now, the district court in this case looked at these issues and tried to figure out whether or not 2017 subsection 4 was intended to overrule the prior precedent from this court and concluded it wasn't. In fact, the district court here found that the statute does not contain any language to suggest that a public body divests itself of the ability to meet and approve a contract negotiated by its representatives and the union. Now, there's been not a lot of case law ever since these came down, but we did identify the Moravia Community School District case where this wasn't even the subject of dispute because it was clear to the court and it was clear to the parties. We would respectfully request this court affirm the district court decision. Thank you for your time.
Mr. Tice, thank you as well. Mr. Gribble, you may present your rebuttal.
Thank you, Your Honor. First of all, with respect to the 1970 case, we'd like to, again, remind the court that that was before collective bargaining, before the enactment of Chapter 20 in 1974 and 1975. And you did consider the question in 1978 of the region's status as an employer, and that was Iowa State Education Association versus the state of Iowa. It was 269 Northwest 2nd, 446, and you found that the state is the employer, the regions has the responsibility for bargaining for employees at the regions. I'd like to address a little bit more Judge Mansfield and Judge Wiggins' questions, I think, with respect to acceptance here. I think, first of all, we talked about collective bargaining. We have a long line of cases starting with Sergeant Bluff in which you recognize the unique nature of collective bargaining and the special relationship and the fact that collective bargaining agreements were not ordinary contracts. You've looked at this in a little different way than other contracts themselves. But Pepsi-Cola and the cases that follow make it so clear that unless the employer explicitly withdraws the offer in writing, as you stated, Justice Mansfield, that even a strike, a counteroffer, walking out of the negotiation sessions, telling the employer we're never going to reach an agreement, none of that is sufficient under the case law that we have.
Counsel, are there questions of fact precluding summary judgment?
Your Honor, I do not believe so, and that's why I wanted to address that question. I think that the offer is quite clear that the contract complete agreement was drafted by the regions and offered to the union. I think the ratification is clear, so the question would be on acceptance, and that's why I wanted to hit that and say that that the words, even taking them as completely true, that we don't think we have an agreement, we need to continue to bargain, is not enough to constitute a withdrawal of the offer that was made and accepted in this particular case. Also like to add that with respect to the negotiation process, it is kind of a windowing down. There's an assumption that the parties will make agreements on some items as they go through the bargaining process, if compromise, acquiescence, trading all takes place, so that by the time you get to arbitration, you don't have a complete agreement, but you may have an agreement on everything but wages, but there's no vote because you don't have an agreement. So you could have an agreement on 24 or 25 items, and still under the law there would not be, even if the rule were valid, there would still be no vote because you don't have a voluntary agreement. So the arbitrator's decision then, along with the other items that the parties have settled at the bargaining table, become the parties' collective agreement by operation of law. And if you were to overturn that, we'd be overturning a lot of contracts in Iowa for the last 40 years, that under 2211, the arbitrator's award and the other items the parties have mutually agreed upon at the bargaining table constitute
Here's
contract.
what go ahead, I'm sorry.
There. You're asking, or you're arguing to the court that the representatives for the regents should have specifically said certain language, if we're going to interpret it as being withdrawn, that they should have specifically said something instead of their actions. Couldn't that be true of you as well about that conversation on January 17th? Couldn't your representatives have also been more clear that we are not countering your offer?
I think that the discussion itself, Your Honor, respectfully, is clear that all the representative asked at that time were better terms available on two issues, and that was weekend option and probationary period. But he never suggested any other proposal. In other words, he never made any proposal on those two subjects or any others, or made a counter proposal at that particular time. So I believe that is clear, the nature of that discussion and what it was, as the district court found. There was no counteroffer presented, merely an inquiry for better terms, and under the law that applies to collective bargainings or even regular contract law. That would not constitute a contract counteroffer. There'd have to be an offer that was different, offering differing terms.
I'm sorry. Let me kind of try and cut to the chase, at least as far as I personally view the case. And here's the email that I think creates the most problems for your client. On February 1, your negotiator, Jim Jacobson, writes Mr. Galloway and says, on January 31, during a telephone conversation, you and Tim Cook informed me that the Board of Regents believed the parties had not, in fact, reached an agreement. As I said yesterday, SEIU plans to hold its ratification vote in the very near future. I will inform you of the results. Doesn't that confirm that, at least under that second part of the Pepsi-Cola test, your client reasonably believed that there wasn't an agreement pending to be ratified? I mean, that's what Mr. Jacobson said, right?
That's what he said, Your Honor, but it does not. It's not sufficient. Without a specific withdrawal, the offer remains on the table. Even if the union had made a counteroffer, as Judge Christensen was offering, whatever they did, unless the Regents specifically withdrew that offer, it remains on the table for acceptance. It never was withdrawn. It was accepted. It was ratified. We think under the law as it stands today, there is a contract. Thank you very much.
Mr. Gribble, thank you again. The case of Service Employees International Union is now then submitted. We'll next hear the arguments in UE Local 893.